Hi, this is Brian Bieron with PlatformEconomyInsights.com, and today's topic for our briefing is an effort to give an overview of the increasingly complicated and simply big world of the competition challenges that are being thrown up in front of the largest digital platform businesses. There's just so much going on and so much in the news. I'm not going to try to talk about any single issue in detail here because I'm going to try hard to keep this to a reasonable length, something like 10 minutes. So it's a 10-minute overview of the entire world of challenges that are increasingly facing the biggest four platform businesses: Facebook, Google, Amazon, and Apple. So, what was the deciding factor to do this briefing today? Honestly, it's that there are so many stories right now about the collection of state attorneys general who are getting together to investigate Google and a separate group, Facebook. Why was that the sort of deciding factor? Well, because it's just been in the news so much. And what does it mean when 48, and that's the number that apparently are signing on to the effort to deal with questions related to Google, what does it mean when 48 attorneys general get together on a case? So, to answer that question really quickly, basically, state attorneys general offices are offices of lawyers led by an attorney general, an elected official in each state. Those lawyers work on, among other things, competition and antitrust cases. Now, many of the state attorneys general offices are not actually that big, and the lawyers that they have who specialize in competition or antitrust law is a smaller fraction of their lawyers. And so, in particular, when a competition or antitrust case is going to be a big case, whether that means it's got to deal with a lot of issues or the company and or companies on the other side of the table are big, rich, highly lawyered companies, many times state attorneys general offices work together. It gives them an ability to pool resources. They literally will divvy up the case often times. They'll dedicate lawyers or more than one lawyer to the case. They'll dedicate time of their staff and resources to a case. And so when you have 48 attorneys generals getting together, what that really means is that you have more resources to throw into the case. You also means you have a case that is driven by a committee. In the context of the Google case, I recall reading, I think that there are 8 bipartisan, sort of 4 Democrats and 4 Republican attorneys general who have taken the leadership role. And that is what happens. You have 48 in this case, or with Facebook, maybe 12 attorneys general offices who are participating on the sort of committee who's investigating. But you will have leaders, and then you will also have leaders of particular parts of the case. Because at the end of the day, it's a challenge when you have this pooling of resources and pooling of lawyers to specialize. So the state AG action kicked this briefing off, but I think what I want to do is quickly give a rundown of all the different players who are looking at these companies and what it means. And lastly, what are the big substantive issues? And maybe the last thing after that is, what does it mean for smaller or medium-sized businesses? Because that, to me, is really the relevant question for this PlatformEconomyInsights.com briefing. So you've got the state AGs, but the state AGs are following up on activity at the federal level, in particular by the 2 federal antitrust competition law enforcement agencies, the Federal Trade Commission, the FTC, and the Department of Justice with its antitrust division. So you've got the FTC and the DOJ and the state AGs all right now in various ways looking at the four big companies, although the state AGs, as I said, are more focused on Google and Facebook. So what are the DOJ and the FTC doing? Well, both the DOJ and the FTC are involved in two different kinds of efforts right now aimed at these companies. One is overall reviews of the state of competition law in the United States in the context of big digital platforms and the digital economy. So you had the FTC, who did a very large series of public hearings last year. They're putting together a report on the big topic. You've also had the DOJ Antitrust Division, led by Malcolm Delrahim, announce a very similar effort, essentially a high-level overview of the state of competition law in America and how it relates to the digital economy, opening up questions as to whether there need to be changes. You also have the DOJ and the FTC both taking the lead on specific investigations. Because at the federal level, you have two agencies who deal with antitrust law, and you really only can have one take the lead on any specific investigation or review. One of the processes that happen at the federal level is the FTC and the DOJ literally sit down, sometimes physically, sometimes virtually, and they assign leadership to one of the two agencies on a specific matter. Sometimes it's based on expertise, sometimes it's based on the need to just divide up work. In the case of these big four giant digital platforms, the FTC and the DOJ earlier this year got together and agreed that the Federal Trade Commission would be the lead federal agency on matters relating to Facebook and Amazon, and the Department of Justice would be the lead agency in relationship to Google and Apple. So just keep that in mind. Now, that's not the only thing going on at the U.S. federal level. You also have the Congress taking a look, in particular in the U.S. House of Representatives, the Department of Justice's, the Judiciary Committee's subcommittee on antitrust, led by David Cicilline of Rhode Island, is engaged in a series of hearings on a very similar set of topics, both specific inquiries about the specific digital platforms and also a broad overview of, again, this big topic: how should competition law deal with the digital economy? So you also have the Congress looking at it, in particular the Judiciary Committee in the House of Representatives, its antitrust subcommittee. Now, that's a quick snapshot of the United States. The rest of the world has governments getting just as involved, and one of the news items that's very timely is the fact that Margaret Vestager, who has been the Commissioner of the Competition Authority in the European Union, so the EU's top competition leader, was just recently named to that position in the new European Commission. So she's going to serve, if she serves out her term, another 5-year term as the head of the European Competition Authority, and she has been extraordinarily active on issues related to the digital economy and the big four digital platforms. And so that is going to be another entire topic for another briefing. But you have Europe, led by Commissioner Vestager, very much engaged in this. You also have national competition authorities in a large list of countries, in particular big important markets, getting increasingly active. And the ones at the top of the list would be Germany, France, Italy, the UK, Australia, Korea, Japan, even Canada, Brazil, Mexico, India. They're all getting involved. Many of them with very specific cases targeting very specific companies with some very interesting angles on how this all will work. Now, some of the big issues, some of the big topics are reviewing, for example, whether or not mergers and acquisitions, in particular acquisitions, by these giant platforms should be evaluated with a different standard than in the past. Some of the considerations are whether or not these companies are more aggressive, using acquisitions to stifle future competition. There's also simply a question as to whether or not, as such large platform companies, by acquiring other businesses, they're able to get too much control over important data or solidify control over markets that in many cases they already dominate. So you have issues regarding mergers. You have issues regarding whether data, and in particular from the perspective of privacy, should be considered in a new way by competition authorities. I'll harken back to the discussion of, or the list of the countries we just mentioned. And for example, the German Competition Authority and most recently announced the Japanese Competition Authority are both taking a specific look in different ways as to how data and privacy might be appropriately considered in the competition context going forward. So in a case that the German Competition Authority has brought against Facebook regarding data policies, the Competition Authority suffered a setback in a German sort of regional court, but is committed to continuing to fight and claims that actually there is an absolute link between data policies and competition law for these big companies. The Japanese Competition Authority has recently outlined their ideas regarding how the data practices of the giant platforms may in fact violate what they consider a sort of superior bargaining position concept in competition law. So we're going to, and questions have been raised in Japan already as to whether or not that really will work. Now, I mentioned Australia. You know that Platform Economy Insights has done a lot of reporting on the very significant review by the ACCC, the Australian Competition and Consumer Commission, focused in particular on Google and Facebook, but also looking at Twitter and other social media platforms. Their efforts heretofore have been focused very much on the digital advertising and media and communications markets in Australia, and whether or not the large platforms have destabilized and undermined those markets. And lastly, you have issues regarding platforms and self-preferencing. This has been a big issue. It's something that Commissioner Vestager in Europe has looked at in depth already when she was reviewing Google in their shopping case, or Android and the question about the application of apps to the phones. This is also a topic that's been raised in the context of Apple and the App Store. Spotify's challenge, bringing a case in Europe, a complaint to Commissioner Vestager, is really about the treatment of Spotify's app in the Apple ecosystem. Leveraging is another big issue. It's something, for example, that has been looked at already, is being looked at by the Italian Competition Authority, looking at Amazon and the relationship between Amazon's logistics business and the Amazon marketplace. That's a very, very interesting investigation. Might be the most relevant one in the case of Amazon. I mentioned preferencing and the self-preferencing of Amazon's products on their own marketplace where they compete, where third parties compete. This is something that Vestager has talked about. It's absolutely been a matter that is being looked at in the United States on that range of investigations that are going on. So platforms and preferencing is another huge issue. Where's it all going to go? And what should small companies be concerned about? Well, I think at a high level, smaller enterprises and mid-sized businesses should be concerned if these competition investigations end up driving governments to not impose restrictions on the giant platforms, but instead decide that it's better to regulate the entire market. That's the kind of thing that could really rebound to harm smaller and mid-sized businesses, because at the end of the day, these giant platforms are far more capable of handling new regulatory burdens than smaller players. It also will tend to lock in current business models and make it much harder in narrower sort of regulatory channels to do things that are new and challenge the giants. So that's risk number one, is that competition concerns end up leading to broad regulation instead of competition sort of remedies. Another big one is, without question, this investigation and change in potential merger review standards. There's no question that the digital economy and entrepreneurs have grown up now in sort of an environment where being acquired by the largest platforms is a major sort of cashing out model that entrepreneurs take. They develop new services and then sell them off in many cases to one of the big rich players. If that gets changed based on a reevaluation of merger standards, that will be a significant change in the ecosystem that will need to be looked at. So I think those are the two biggies. We've already run over, it's not surprising, you can't look at the world of competition challenges to the big four platforms in 10 minutes or less. That's one thing we've learned here. But there'll be more to come, and this was just aimed at being high level. Every one of the topics I mentioned could probably be the subject of another briefing. And in fact, if you're interested in more, you can contact platformeconomyinsights.com by email. The link is down below. You can also look at us on the internet, www.platformeconomyinsights.com, as well as sign up for the email list where things get sent out in much smaller little chunks. With that, this is Brian Bieron with platformeconomyinsights.com with a briefing on the world of competition challenges being directed at the giant platforms and what it means for the rest of the digital platform business ecosystem. Until our next briefing, have a nice day. Bye-bye.